Okay. Who's counsel for appellant?
I am, Your Honor. Carl Willander.
Willander?
Yes, Your Honor. Willander. Yes.
Willander. Okay. Good morning, and you may proceed whenever you're ready, sir.
Thank you, Your Honor. I'd like to reserve 5 minutes for rebuttal, please.
All right.
This is a case, neglect and abuse case against a nursing home, its management companies, and operators pursuant to Chapter 400. It's exclusively arising out of a 2.5-month stay from August 12th of 2017 to October 25th of 2017, and exclusively for injuries that Ralph Ballard sustained during that 2.5-month stay. The trial court here erred in compelling arbitration in this case based on a 2015 arbitration agreement because the 2015 arbitration agreement was inapplicable. It stemmed from a totally separate and unrelated admission that had concluded over 2.5 years prior to the suit upon admission, and where the admission paperwork for the relevant stay expressly superseded all previous agreements between the parties. The trial court's order was predicated on the validity and enforceability of an inapplicable agreement, and it must be overturned. And therein lies a threshold issue. The trial court also dealt with waiver, but we don't get to waiver before disposing of the inapplicable 2015 agreement. In fact, we don't even...
Counsel, if you don't mind, I'd like to just touch on that a little bit. Your brief reads in the nature of surprise. Hey, where'd this 2015 agreement come from? It wasn't in their motion. You know, we're surprised. Our due process has been violated. We weren't put on notice. We didn't come here prepared to talk about that. But the reality of it is you spent a lot of time in discovery with opposing counsel talking about the 2015 agreement. And what's notable about the two different agreements is the deceased signed the 2015 agreement and the personal representative with a power of attorney signed the 2017 agreement. So clearly you were on notice of this agreement. You can't really claim surprise. And this idea that your due process rights have been violated because you didn't know this was coming up, that's a hard one. So why don't you try to walk me through it and try to convince me, because as I stand right now, I am not convinced.
Well, we'd look at the plain language of the agreements too. To answer their question, though, there was 121 days of addressing the motion to compel arbitration pending the defendant's file. It wasn't until the day of the hearing where the first time they moved on to 2015. Now, this was separate residencies. I mean, we have a 2.5-year gap. But more importantly, when you look at the actual documents and the agreements between the parties, the 2017 documents, it states clearly this agreement, and this is from the residency agreement that was part of the paperwork that was signed. This agreement executed by both parties represents the entire understanding between the parties and supersedes all previous representations, understandings, or agreements, oral or written, between the parties. And when you take that and compare it to the...
It says it supersedes it. It didn't say it voided it, though, did it? I didn't hear the word void in that recitation, did I?
Well, I think that supersedes, though, would be sufficient, Your Honor, but I also believe...
But we also know that the intent of that language is to eliminate disputes over oral representations and things of that nature, right? And this is a form agreement that everybody signs when they walk in the door there. And that purpose of that language is to make it clear that this is the writing that controls our understanding at this point. It doesn't specifically void a previous agreement, correct?
You know, I would disagree in that when you read it.
Well, does it use the word void, and does it say a previous agreement?
Well, with respect to the fact that it actually, the clear language says oral or written agreements, and then you take it.
It says it supersedes it, which means if there's a conflict in the two, it will control. It doesn't say it voids it. That's what supersede means.
Well, and at the same time, the arbitration agreement that we have, that was actually, there was one in 2017. The language of that agreement says, if the alleged acts underlying the dispute occur prior to the cancellation date, this agreement shall be binding as to those alleged acts. If not canceled, this agreement shall be binding on the resident for this and all subsequent admissions to the healthcare.
Did you raise any of this below?
Your Honor, these were, and I think that's part of when you go to the surprise and the due process, there were, I believe, counsel did for appellant, did preserve.
So you were really surprised in this hearing before the judge that the 2015 agreement was even mentioned, even though you had engaged in a lot of discovery and a lot of discussion with opposing counsel about this agreement?
I won't necessarily say mentioned, but that they were going to move upon it. Regardless of that was the choice that counsel made, was to move upon that 2015.
So you went to a hearing unprepared? You were not expecting that this agreement, which had been featured in discovery, was not going to be discussed?
Well, I would touch on that when you look at the case law that actually surrounds subsequent admission agreements. And the defense, referenced it, which I think invited error from the trial court in bringing up cases that were recent, but didn't actually cite the cases. They'd been cited in their subsequent briefings that they filed very recently, but the Bryant case from the 4th DCA and the Voorhees versus Mallard case, a close inspection of those cases reveals that when there's a subsequent admission and actually subsequent agreement signed, it's the exception rather than the rule to enforce a prior agreements with unrelated residencies. And the way we get there is when you read the Bryant case, and I think the rule that comes for the subsequent residency is that first and foremost, there was no subsequent enforceable contract in Bryant, and that's the case they cited. There simply wasn't a contract. Here we have a subsequent contract. They had a subsequent contract. And first there, the court will look to whether or not the parties continue to perform under the terms of the original contract. And that was Bryant. Second, if you don't have that, which is the other case cited by the defense, which is the 2nd DCA's case, this court's case, the Voorhees versus Mallard, where no evidence was presented as to the parties' respective performance during the readmission, the court will look to the face of the documents for language that the arbitration agreement clearly contemplated readmissions. We don't have that here. And so getting to that rule, number one, those cases wouldn't be applicable here because there is a subsequent contract which defines the relationships between the parties, number one. Number two, the evidence establishes that's before the court, looking at this de novo or to whether or not the court's ruling was guided by competent substantial evidence, was the evidence established that the parties did not continue to perform under the same contract. The defendants filed in their appendix, and it's our appendix, the total admissions agreement for both the 2015 and the 2017 paperwork. The admissions agreement each had an arbitration agreement that they're seeking to enforce attached to them. That contract, the 2017 residency contract, guided the parties. That speaks directly to how the parties would continue. The 2.5-year prior residency agreement had no guidance as to the parties. It did not define the relationships of the parties in 2017. None of the paperwork did. And unlike Bryant and Mallard, there is a superseding language in effect in the paperwork that was signed in 2017. And so with those respects, the case is that it is the exception rather than the rule when you've got separate residencies. When people sign an admission paperwork, it's not to survive for eternity based on arbitration. I think the reading of the actual original arbitration agreement is important, the 2015 one. It only says this agreement shall remain in effect for all care rendered at the healthcare center. That's what was pointed to by appellee. That is not clear language that would suffice from the 2nd DCA, this court's case in Mallard, where it clearly said it governed subsequent admissions. Furthermore, if you looked at the 2015 agreement, it doesn't even apply to management companies or operators. It only applied to the licensee. If you looked at and that's on page 193 of Appendix G, when you look at the actual language under please read carefully, it only applied to the licensee. Whereas when you look at the 2017 agreement, it would have applied to management companies, parents, and subsidiaries. Now, the fact is that appellees at the lower court, they chose to make their primary argument after 121 days of dealing with this issue. For the first time, they moved to based on a 2015 agreement, and they state in the transcript, which is Appendix J, pages 258 through 259, our primary argument is the first optional arbitration agreement executed by Mr. Ballard is valid and enforceable. Taking the law with respect to subsequent agreements and just looking at the plain language of the contracts that were before the court, it would be error to allow this case to proceed under arbitration based on the 2015 contract. First and foremost, and that governs the issue because the entire order was predicated on the validity and enforceability of the 2015 contract. Appellate at the lower court and trial hearing did not ever waive his right or objections to the 2015 contract. And I think that portion of it, I think is clear from the record. I would also, moving forward as to why at this point the court should overturn the lower court and send the case back down to proceed in litigation, is because the trial court below chose not to enforce the 2017, any other agreement, only chose to enforce the 2015. And that, the fact that based on the case law, that contract should be voided. Your Honor, I'd like to, in our brief, we speak to waiver, I think, at great length. We go into great length on waiver. I'll touch on it briefly, and I'd like to reserve the, then I will stand down and turn over the argument. But in the case law on waiver, I think what's important is that there's several cases there cited. The Green Tree case from the second DCA. We also rely on Boylan, a recent case where, and in these cases, and the Lions Gables case, in these cases, there are requests for discovery under 1.280A or requests for copies. The party never actually received discovery. In this case, what takes it to a whole nother level is that counsel for appellees at the deposition engaged in merit-based discovery and actually got answers to that merit-based discovery. And it wasn't insignificant. And we detail it in our brief, and I'll stand by what we detail in our brief, starting on page 25 and listening through 27 and 28. It went into the cause of death. It went into the complaints at the residency for the wounds that developed at the residency. It went into witnesses. It went into the cause of death of the spouse. It went into a number of different areas, which would be the evidence that the defendants would try to receive, appellees would receive, had they filed documents and requests for discovery like had been done in Green Tree. But in Green Tree, for example, there was never any findings on it. They were never produced discovery. In this case, they engage in merit-based discovery. And so based on the totality of the circumstances, it is far greater damage done than was done in the other cases cited by plaintiff, by appellants here. And I would point out that one thing that was significant to the court in Green Tree was that counsel represented at a prior hearing in Green Tree acknowledged that at the hearing to get an order to put a stay on discovery, which we don't have in this case, they acknowledged that participation in discovery related to the merits of the case would result in waiver of its claims to right to arbitration. And in this case, when they filed the motion to compel arbitration, appellees stated specifically, and this is on a record of 047 through 048, it is well established that a party may waive a right to arbitrate by taking an action inconsistent with the exercise of that right. Here they went far beyond that. And it's their responsibility to safeguard, and this comes from the Raymond James case of the Florida Supreme Court and all the way cited in all of the cases that we cited for this proposition, Green Tree and Boylan and Lion Gables, that the right to arbitrate must be safeguarded by a party who seeks to rely upon that right. And that party must not act inconsistently with that right.
Don't the cases also say that, you know, that all doubts should be resolved in favor of finding the right to arbitrate, and the courts should be careful to respect that right and that sort of a thing? I mean, you know, that's the overwhelming, you know, structure of the case law, is that when in doubt, find that the parties have a right to arbitrate. Isn't that true?
Well, that is certainly true, but it's also true that, which is in Florida, a party, it is very clear, a defaulting party that acts inconsistently with the arbitration right can waive that right.
Didn't the trial court also find that, at the hearing, didn't counsel give sort of merits neutral explanations for the questions that were asked? And so, okay, if you look at them one way, maybe they went to the merits, but really here's why I was asking them.
There seemed to be confusion back and forth, and I think that part of the process, even appellees acknowledged in their briefs and responses that there were questions that were not merit-based. There's been disagreements on how many of those, but there are significant questions that, and the court can look at these de novo. Or
well, what's the bright line? I mean, how does a court tell?
Well, you can look at I think the court can analyze.
Well, the idea is if 80% of the questions are clearly based on, are not merit-based, and only 20% arguably are, I mean, what's the mix? It's a case-by-case basis, isn't it? Isn't it, you know, abuse of discretion sort of type standard? Isn't that what it is?
Well, in this juncture, first, again, going back to it, the entire order is predicated on a 2015 contract, and that's inapplicable. So we shouldn't even get there per se in this argument right here. But speaking to it, in this case, taking a look at the other cases, as previously stated, this involved soliciting merit-based discovery responses and actually receiving them. And it wasn't limited to a certain section. It went into areas that the court.
Once again, back to my question. The trial judge is sitting there listening to this argument. The trial judge has to draw a line about whether they've waived or not based on the discoveries focused on merit-based discovery. How does a trial court draw that line? Isn't it an abuse of discretion that the court does on a case-by-case basis? Isn't that how it works?
It has been. I think that there is a lesser deference to that when it's based off of the same items. There was no.
So again, what then is the bright line rule that a trial judge must apply in making this call?
There is no bright line rule.
Well, that's my point. That's my point. It's abuse of discretion, right?
And based on the totality of the circumstances, I think the evidence.
So that means that no reasonable judge would have made the call that way. And in order for you to prevail, we have to determine that no reasonable trial judge would have made this very same call that this trial judge did on this issue. Is that correct?
Yeah, I would.
Isn't that the standard, counsel? I'm just asking I'm throwing you a softball. I think everybody knows that's the answer to that question.
I think under the circumstances of this case, when you look back at how the court was made it to that position, the court was brought in, and initially I think that the attempts by appellees to bring in the 2015 agreement at that late hour was an attempt to provide cover for the fact that they waived arbitration based on the 2017 agreement. Now, the court went in and I think was confused on that too, because in reading the deposition, the hearing transcript, the judge was asking, I'm confused on the relevancy of these different questions. They had never moved onto that contract before. And while I acknowledge that waiver would be a waiver of right to all, we do think there is error, but based on the record and the late entry of that order, I think it ties into the due process. I think the process was confused, and we know that in here is that you really cannot get to that issue without the threshold issue is whether or not there's an enforceable contract.
Sir, I just want to let you know you're actually at the end of your time. I'm going to give you a little bit because we started asking you questions just as you got, and you needed to answer them just as you got to your 15 minutes. But if you want to save any more time, you should wrap up.
Okay, I'm just going to say one thing is that here that I think it is important that the trial court chose not to and purposely did not enforce the 2017 agreement. So if this court doesn't find the 2015 agreement valid and enforceable based on the arguments I've made and that are briefed, then we do not even get to the 2017 in the waiver argument. And thank you.
Thank you. Ms. Fishman, whenever you're ready.
May it please the court, my name is Jenna Fishman from Lewis Brisbois, and I represent the appellee defendant in this case, Boca Ciega, on behalf of all the appellee defendants. This court should affirm the trial court's order compelling arbitration because it wasn't an abuse of discretion to compel arbitration under the February 24, 2015 arbitration agreement and under the totality of circumstances under the substantial and competent evidence supports the lower court's finding that Boca Ciega's questions at plaintiff's depo were not inconsistent with its right to arbitrate. You heard a lot from the appellant's counsel discussing a 2017 financial agreement. However, appellant counsel is conflating the admissions agreements with the separate optional arbitration agreements in this case. In this case, we have a 2015 optional arbitration agreement, and we have a 2017 optional arbitration agreement.
So what was the judge's rationale for landing on the 2015 agreement and not the 2017 agreement?
I don't specifically know the judge's rationale because it isn't in their order. However, the judge was completely permitted to do so because the 2015 optional arbitration agreement was valid on its face. It was authenticated by Ms. Stahl, her father's signature on the agreement. It was performed. There was nothing raised by the appellant in the lower court that it was invalid. So under this court's precedent in Spring Lake NC LLC v. Figaro, 104 Southern 3rd, 1211, there's an insurmountable presumption that the agreement is valid and can be ruled on its face.
Your motion to enforce arbitration proceeded on the, basically identified the 2017 agreement as the basis upon which you were bringing your motion. And you've heard and read the opposing counsel's brief that they were surprised. They got into that hearing and they had no idea the 2015 agreement was in play and their due process rights were violated because they didn't have notice and they didn't have the opportunity to prepare for it. And while I certainly didn't give Mr. Winlander any space on that, I do respect his position on it. He makes a credible argument on that. As a lawyer, I would not be happy if I went into a hearing based on a motion that identified agreement, and then all of a sudden I get hit with an order that's ruling against me, identifying an agreement that was not placed in the motion. I wouldn't be happy with that. I'd feel like, oh my gosh, what happened here? So why shouldn't we be concerned about that?
So Your Honor, could we have done this better? Sure. Is it a due process violation? No. The three elements of due process is opportunity to be heard, notice, and whether there's a disadvantage. At the hearing, appellant's trial counsel had an opportunity to be heard about the 2015 agreement. All they did at the hearing was make a general objection. At A275, the court specifically asked trial counsel, you brought up some authentication issues and things of that nature. Do you have any other argument than this aspect of waiver? And what plaintiff's counsel said was, here's the issue, Judge, is they filed an affidavit. I don't think they've moved. I mean, there's nothing been admitted into evidence. I don't think we need to get there today. They had an opportunity to bring this up then, and they didn't. They didn't ask for a continuance. They didn't ask to withdraw the notice of hearing, which they filed even before they responded to our motion to compel in this case. They weren't abruptly ended from cross-examining. They weren't prevented from putting on evidence. And it's frankly a misrepresentation that they didn't know that this arbitration agreement, the 2015 one, was at issue. Because if you look at the arbitration-related discovery in this case, which plaintiff, by the way, initiated, 68 days before the hearing, plaintiff's request for admission, which attached the 2017 agreement, asked defense counsel or defendant whether they were relying on any other agreement in this case, other than the 2017 arbitration agreement. Defendant responded no. They denied that. Then October 14th, 58 days before the hearing, defendant propounded their own arbitration-related discovery, including the 2015 arbitration agreement as Exhibit A to the request for admissions. Not only was this served on plaintiff's counsel, it was filed in the record. Then on November 13th, when plaintiffs responded to this discovery, they authenticated Mr. Ballard's signature on the 2015 agreement, and they also, for request for admissions number 6, to the question on or about February 24th, 2015, Ralph Ballard signed and initialed, as of February 24, 2015, this is request for admission number 4, Ralph Ballard has not been declared incapacitated under Florida law. They admitted it. So not only did they authenticate his signature, but they also admitted that he was competent at the time of signing. Then we get to the depo on November 19th of Ms. Stahl, the personal representative in this case. And again, she confirms her father's competency in 2015, and also confirms that he did sign the 2015 arbitration agreement. And A101, she even says on the record that she's familiar with the 2015 arbitration agreement because she's seen it before in this litigation. This was not a surprise. And to get rid of any doubt whatsoever, defense counsel, again, before the actual hearing took place, refiled all the depo exhibits, which included the 2015 arbitration agreement. They refiled all the power of attorneys, the admissions agreements. This was repeatedly shown to plaintiff's counsel. It was not an ambush situation. All of our cards were on the table. Getting back to the argument about whether this 2017 finance agreement supersedes a 2015 unrelated optional arbitration agreement, that argument doesn't have merit, Your Honor. As you know from the 4927 Verus Road LLC versus Mallard case, which Your Honor Morris concurred in that opinion, which is 163 Southern 3rd 632 Floss 2nd, 2015. In that opinion, this court ruled that a court can summarily determine that an arbitration agreement, the first one, can be binding on its face and apply to later residencies. That is exactly the facts here. Although the complaint in this case implicates Mr. Ballard's stay during the 2017 residency, just like in Mallard, the complaint was centered around the third readmission, even though there were 2 prior admissions, and the third admissions agreement was signed by an improper power of attorney. This court found that it was error that the court did not compel arbitration based on the plain language of the first admissions agreement, which was binding on its face. In this case, if you actually look at the 2015 arbitration agreement, the language in this agreement is, this agreement shall remain in effect for all care rendered at healthcare center. All care rendered. What do they define? What does the agreement define all care or healthcare center as? It defines it as the Springs at Boca Ciega. Both.
What about the language in the 2017 agreement says it supersedes all agreements?
So the 2017 finance agreement within the admissions agreement supersedes prior admissions agreement. In contrast to Mallard here, the arbitration provision is not incorporated into the admissions agreements. It's a separate agreement that has to be separately signed. So it's the 2017 financial agreement, if it supersedes prior admissions agreement, is completely irrelevant.
Yeah, okay.
So getting to the last argument that is raised on appeal in this case, waiver, Your Honor, question appellant counsel about how do you determine this bright light rule under the substantial and competent evidence standard? I think Your Honor hit the nail on the headboard. It's not a bright line rule. It's a totality of circumstances standard. In our answer brief, we cited a multitude of cases, not only in the arbitration context, but in other contexts where it's extremely important for the courts to consider the specific facts in the case. How you determine that based on the case law is whether there is an active or extensive participation on the merits. That is what the case law says. That is why there are all these different cases coming different ways, because the courts are looking at what actually happened in these underlying cases. For instance, in this court's Audiovisual Innovations v. Speechback 119 Southern 3rd 552, 2nd DCA 2013, which Judge Morse, you were also on the panel. In that case, you reversed when there was an actual mediation held. There was a 5-month delay in requesting for arbitration, and what defense counsel kept doing was asking for extensions of time to answer the complaint. Here, nothing even close to a mediation happened. What happened here, if you look at defense counsel's actions, is everything was centered around compelling arbitration. We didn't answer a complaint. We didn't move to dismiss. We didn't file a motion for summary judgment. We didn't conduct merits discovery. The only thing we did in this case was we did propound arbitration-related discovery after plaintiff initiated the same. And then we took Ms. Dahl's deposition. And if you go to the actual deposition questions, all roads lead to exploring Mr. Ballard's competency. Not only was this relevant to the validity of the 2015 arbitration agreement, it was also relevant to the validity of the 2017 arbitration agreement, because in 2015, Mr. Ballard signed a power of attorney giving Ms. Dahl the ability to act as his power of attorney. So if Mr. Ballard was incompetent in 2015, he also wouldn't have, Ms. Dahl wouldn't have had, or was competent in 2015, or wasn't competent in 2015, then potentially his power of attorney could have not been valid. And then that would cause a problem for the 2017 arbitration agreement. So it doesn't make sense that we couldn't explore competency. Furthermore, this was a 90-minute deposition with a 70+ page transcript. And most of the questions, as Your Honor recognized, were, Your Honor, irrelevant to the questions of merits. This goes to funeral arrangements, caretaker testimony, whether Ms. Dahl wanted to transfer her father to a facility that has nothing to do with negligence pertaining to an infected ulcer, which is alleged.
I'm not sure what that had to do with, to be honest with you, but there were a lot of those questions.
Sure. Sometimes in depositions, you need to establish some background information. A few questions may have not been exactly on arbitration, but they certainly didn't go to defending against the negligence claims. The few questions that we did concede in our brief deal with the wound testimony, as we phrased it, were at most 10 questions in the entire deposition, lasting only a couple pages. And out of those 10 questions, 2 of them asked Ms. Stahl to answer whether her father had any complaints post 2017 residency. The remainder of those questions dealt with where she was getting her notes from. She was confused about the year. All of that is still unclear. What we did after that deposition is we didn't ask for medical records. We didn't take expert depots. We didn't depose treating physicians. All we did was ask a couple questions to establish that the claims are arbitrable, which is one of the elements to compel arbitration. So this mere blip in the deposition, where the case has been entirely focused on arbitration, certainly does not constitute waiver. As Your Honor also recognized, if the court has any doubts as to waiver, they must construe it in favor of arbitration. That is the long-standing public policy. Then we go to this Boylan case, this 50 DCA 2019 case that plaintiff's counsel was involved in, which is the only case that we have dealing with questions asked at a deposition where there was waiver and arbitration. That case is distinguishable because in that case, there was an actual discovery order limiting the arbitration discovery to certain parameters. And what the trial court did in that case is say the questions asked at the deposition were extrinsic to the discovery order. So when the 50 DCA got the case on appeal, they affirmed the lower court's order denying the motion to compel arbitration based on this violation of discovery order logic. Even though they cited totality of circumstances, we're at a loss to really understand what questions were asked at that deposition because we don't know, because the 50 DCA didn't look into it. So I find that has very little persuasive value on this court. Finally, under Tipsy Coachman, it's clear that defense counsel moved to compel arbitration under both agreements. We think standing alone, the 2015 arbitration agreement is completely valid on its face, and the court was entirely in its right to enforce it. It was superseding on its successors, that language in the arbitration agreement itself. It applied to all healthcare at Boca Ciega. However, if the court considers Tipsy Coachman, the ruling to compel arbitration was the right result, either under either both agreements. The record evidence here clearly supports that also the 2017 arbitration agreement was valid on its face. Plaintiff also, in her responses to the request for admissions, admits that she signed this agreement. She verifies her father's signature on the 2015 power of attorney she was operating under. She admits that Boca Ciega emailed the admissions agreement and the 2017 separate optional arbitration agreement to her before she signed it. They called her about it. She admitted at her deposition she never read it. She spent 5 minutes total looking at it. And Ms. Stalt also testified that she's a mortgage broker. And as a mortgage broker, you're someone in your profession that's used to looking at sophisticated documents and reading the fine print. However, there was no fine print here on the 2017 arbitration agreement, like the 2015 arbitration agreement. All of the terms were plain and clear. And also we have Ms. McDonald, defendant's corporate representative's affidavit here, who explained the procedures under, she went over the 2015 arbitration agreement and also the 2017 arbitration agreement. She signed the 2017 arbitration agreement on behalf of Boca Ciega. And she said, for all arbitration agreements that are admitted for their facility, which are optional at all times, they always give the signer a chance to consult with an attorney and a chance to rescind. This wasn't a situation of undue influence. Both these agreements were valid on its face. So in conclusion, this court should affirm the lower court's order compelling arbitration.
Thank you. Sir, you have about 1 minute.
Be quick. First, the court asked what the rationale was behind the court, and I think that it's important to bring back to the appellees invited this error. They, at the hearing, relied on this agreement 2015 for the first time as their primary agreement, and brought the court down a line of questioning on page 279 of the transcript that the second agreement wasn't needed, and that perhaps the second agreement wasn't needed. And the appellee said, yes, that's correct. All right, so I think I understand your argument. The court and Tipsy Coachman doctrine shouldn't apply. The court, it's not a situation where they found based on two agreements, they found both enforceable. Specifically, the lower court did not find the 2017 enforceable. That's why in this case, the 2015 is what the court needs to decide. It's unenforceable. It's not valid for the reasons I've stated, and it should be, in the case, therefore, should not be compelled to arbitration. When we look at back to the 2017 agreement, it was cited that it doesn't reference the financial agreements that say the document signed would supersede all prior documents, but it does in fact rely on it.
Sir, I'm sorry, sir, you need to conclude, please.
Okay, on page 237, the arbitration agreement from 2017 says arising out of or relating to healthcare centers admission agreement. So the admission agreement is related to this arbitration agreement signed, and it's unenforceable. Thank you.
Okay, thank you both. Our next case this morning is YH Saul Holdings versus